Welcome. By the end of this tutorial, you will know exactly how to prepare and submit a flawless divorce or dissolution application. Before you begin drafting, you must verify one absolute prerequisite. Under the law, you cannot apply for a divorce or dissolution within the first year of the marriage or civil partnership. If 365 days haven't passed, the court will simply not process the application. This diagram shows the core items you need in hand once you clear that 1-year mark: the completed Form D8, the original marriage or civil partnership certificate, the current court fee of £593, and your statement of reconciliation. Missing any of these elements is the most common reason the family court rejects an application early on. Verifying these physical and financial prerequisites immediately ensures your submission clears the administrative gatekeeping. Step 1 is choosing the appropriate application framework for the parties involved. You have two procedural paths. A sole application means one party, the applicant, initiates the process against the respondent. Alternatively, a joint application allows both parties to apply together cooperatively, sharing the role of applicant. Step 2 is sourcing and preparing the marriage or civil partnership certificate. The court enforces a strict requirement here. You must submit the original certificate or a formally certified copy. If the marriage took place abroad and the certificate is in a foreign language, you must also provide a translation. That translation requires certification by a notary public or an authenticated statement of truth. Do not submit standard photocopies. Supplying an uncertified copy will trigger an automatic rejection by the court. Strict adherence to these evidentiary rules proves the validity of the marriage. Securing the correct documentation now establishes the jurisdictional foundation of the entire case. Step 3 is completing Form D8, or its digital equivalent on the My-HMCTS portal. The Divorce, Dissolution, and Separation Act 2020 removed the old requirement to prove specific facts, such as unreasonable behavior or adultery. Instead, the only requirement is a definitive statement confirming the marriage has irretrievably broken down. Legal professionals must use this digital portal, replacing paper forms. The 2020 Act stripped away the need to cast blame. What used to be an adversarial, evidence-heavy stage is now a straightforward administrative declaration. Step 4 covers the professional obligations tied to the Statement of Reconciliation, required by Family Procedure Rule 7. If you are acting as a legal representative, you must certify whether you have discussed the possibility of reconciliation with the applicant, and whether you provided them with contact information for a mediator. This is a strict professional requirement for lawyers. Litigants in person, individuals representing themselves, are exempt from having to make this certification. For a legal professional, skipping this specific certification directly violates Section 6, Subsection 1 of the Matrimonial Causes Act 1973. Step 5 is finalizing the submission and processing payment. You will confirm that the £593 court fee is attached to your portal application and execute the final submission to the family court. Completing this final action shifts the procedural burden from your desk to the family court's processing queue. Your application is now successfully lodged and active within the family court system. This diagram outlines the immediate next steps. If you submitted a sole application, the court will now serve the documents to the respondent. From the date of your application, a mandatory 20-week waiting period begins. That exact amount of time must elapse before you can apply for the conditional order. By meticulously compiling the application, the original certificate, the correct fee, and the reconciliation statement, the legal process is formally initiated, and you are ready for the next phase.